Good morning, everybody, and a very warm welcome to you to this morning's Think Legal webinar entitled The Commercial Litigation and Labour Law Roundup, February 2024. It's lovely to see all of you this morning and to see our little counter of people attending the webinar go up on our screen. I hope and trust that you will enjoy this session with myself, Nadia, and Cathleen this morning as we go through some of the interesting, controversial, and simply cases that just caught my eye in the last month or so. We're going to be looking through a couple of summaries of the cases to get you up to speed in terms of following these cases and getting into them and adding them to your own arsenal as litigation and other attorneys. So today we will be discussing 13 cases, 5 revolving around company law and corporate governance. We will be looking at 2 litigation and procedure matters. We will be looking at 3 labor matters, a contract matter, even an unjustified enrichment matter, and a wills and estate matter. In preparing today's session, I've worked through the reported judgments that came through in the law reports in the last month, and I've also looked at some more recent unreported judgments, which I think are worth a notable mention, which I will take you through as we go through the webinar. So for those who are not yet aware, thinklegal.coza is finally up and running. On the website, you can register for events, you can join our WhatsApp groups, you can purchase resources, and you can view past webinars. If you are not yet on the WhatsApp groups, please go to thinklegal.coza and you are more than welcome to join our commercial litigation labor law WhatsApp group, as well as our family law WhatsApp group, and then last but not least, our event notifications WhatsApp group, which Nadia is administrating at this stage and sharing as many notifications regarding upcoming events in the industry as we are able to get our hands on. For those of you who are that way inclined, we have prepared the course pack this morning. Today's course, not yet accredited for CPD points. It is solely for self-edification, but if you do want to get your hands on the 13 case law summaries, our slides, as well as the bundle of the cases that we will be discussing today, you are more than welcome to go to our Shopify page, link posted now on all of the chats, whether you're watching from YouTube or StreamYard, etc. You can go to our Shopify page and you can purchase the summaries for 200 Rand. If you are not inclined to buy the summaries, you are still more than welcome to watch the presentation today, and I'm sure it will still be of value to you. So, folks, what is Think Legal? We believe in legal knowledge open to everyone. It's an initiative by Vermeulen attorneys which aims to promote the open sharing of sound legal knowledge. While we acknowledge that the delivery of legal services is for the most part a commercial venture, we uphold the notion that legal knowledge is a public resource meant to be freely available to everyone. Adhering to our dedication to facilitate open dialogue and share legal knowledge among professionals, we organize a variety of activities, including the WhatsApp groups, hosting regular webinars, and arranging social events. As I always mention, Think Legal is supported by, obviously, Vermeulen attorneys, and then also by LawBox practice management software by lawyers for lawyers. Try LawBox free for 14 days, no credit card or contracts or hard sells required. Simply go to lawbox.co.za, register, and start using within a matter of minutes. Final plug before we get into the presentation for today. I'm going to be running my Children's Act deep dive again on the 23rd and the 24th of April 2024. This webinar or this training course is accredited through the South African Association of Mediators, one of the NABFAM constituent bodies, for 5 CPD points. We're going to go through general principles of the Children's Act, children's litigation overview, and then also frequently encountered issues when it comes to Children's Act matters such as guardianship, co-parenting, relocations, terminations of parental responsibilities and rights, etc. For those who are inclined to join us, the cost is 750 Rand per person for standard tickets, 500 Rand for candidate attorneys, and you can use the promo code TL Earlybird for 20% off, which is valid until 20th of March 2024. So, folks, without any further ado, let's get into the presentation for today. First off, we're going to be going into the realms of commercial companies and corporate governance matters. And the first couple of judgments which I'm going to be sharing with you emanate from reported judgments. And you will note that some of these judgments, the date of judgment is quite a while back, vis-a-vis some of the unreported judgments that we're going to be looking at, which are obviously a lot more recent. However, since these matters have now reached the law reports, I think it is very important for us to go through them. The first matter which I would like to talk through, PFC Properties Pty Limited versus Commissioner, South African Revenue Service and others. I've not put the full citation on the slide, but the full citation 2024 1 SA 400, and this is from the Supreme Court of Appeal. The judgment penned on the 21st of July of last year, and it is under the hand of Weiner J.A. Now, what is interesting about the PFC judgment is it deals with a business rescue process which was entered into during final winding up in terms of the Companies Act, Insolvency Act, etc. PFC Properties, the applicant or the appellant in this case, appealed the final winding up order and the dismissal of its business rescue application. The business rescue application was filed shortly before the hearing of a winding up application, which was brought by the South African Revenue Services. And the SCA made quite a lot of very incisive remarks regarding the bona fide nature or lack thereof in terms of the business rescue application. The court went into a full analysis of whether the business rescue application was made solely to delay or to disrupt the winding up proceedings. And the court, in fact, found that the business rescue application, which was brought at the 11th hour, in terms of the hearing of the final winding up, was an abusive process, and the court found that the appellant had no genuine intention of prosecuting it to conclusion, and it was solely intended to thwart the winding up process. Now, in terms of important legal principles discussed in this judgment, in paragraphs 27 and 28, the principle is discussed that business rescue proceedings should aim to restore a company to solvency. It should not be abused for delaying winding up or gaining respite from creditors, and that you can find in paragraphs 27 and 28 of the judgment. And the court restates what constitutes an abuse of process, and it states that it is when litigation is used for an ulterior purpose or in a way that subverts the rule of law, warranting non-suit. And that's from paragraph 28 to 29 and restated in paragraph 36 of the judgment. It then goes without saying that the appeal was dismissed with costs. Remember, PFC, the appellant, appealed the final winding up order in favor of SARS and the dismissal of their business rescue application. And a notable quote, paragraph 27, cautionary tale to all of us who deal with business rescue matters. Business rescue proceedings are aimed at restoring a company to solvency and are not to be abused by a company with no prospects of being rescued, but mainly to avoid a winding up or to obtain some respite from creditors. Very succinct definition of what business rescue should be versus what it should not be by Weiner J.A. Sitting in the SCA. Just for clarity, I repeat the citation 2024-1 SA 400 SCA, judgment penned on 21 July 2023 under the hands of Weiner J.A. and reported in the SA Law Reports last month. So that was PFC Properties, Pty Limited versus Commissioner, South African Revenue Service, and others, with a cautionary tale: do not abuse business rescue processes. Staying on the topic of business rescue, friends and colleagues, we are going to go through another interesting judgment regarding business rescue, where in fact what we deal with here is not necessarily an abuse of the business rescue process, but the question was whether there was undue preference given to creditors due to some payments which were made by the directors of the company at that stage. So, dealing with McNeil Plastics Pty Limited versus Van der Heer, NO and others, citation 2024, Volume 1, SA Law Reports 468, and this emanates out of the Pretoria High Court. Judgment penned on the 18th of May 2023 by Mogale AJ. Now, before I forget, for those of you who are following along on the bundle or in terms of the summary pages, this judgment can be found on page 2 of your summary and on page 21 of your paginated case law bundle for purposes of this webinar. So as I mentioned, Judge Mogale AJ on the 18th of May 2023, sitting in the Pretoria High Court. What is the background of this matter? So what had happened here is that payments made by Water Africa Systems, which was in final liquidation, to McNeil, who was the appellant in this instance, were declared that they were void due to the fact that they were made after the company was put in final liquidation. However, subsequent to the final liquidation, the company was put into business rescue. And the key issue that the court had to discuss in McNeil versus Van der Heer NO is what is the legal effect of placing a company under business rescue on existing liquidation proceedings. Specifically, does the action terminate and then restart the liquidation proceedings, or does it merely suspend them until business rescue concludes if the business rescue is not successful? So in this instance, the court held that the business rescue did not terminate the liquidation, but suspended it, maintaining the original concursus creditorum. What the effect was of this is that the payments, which were impugned by the court a quo, had the effect of being void. Core legal principles, looking at section 1316 of the Companies Act, where it was held that business rescue proceedings suspend but do not terminate existing liquidation proceedings, and the original concursus creditorum remains intact. And obviously, dispositions made by a company after its final liquidation but before business rescue are void and cannot be validated by the business rescue. Obviously, the appeal under the circumstances was dismissed, and it was affirmed that payments that were made after liquidation but before business rescue were void and could not be validated by virtue of the later business rescue process. Some notable quotes, folks. I've got 3 quotes which I'd like to take you through. I've got one up on your screen, paragraph 23 of the judgment. When the impugned payments were made, the company was already placed under final winding up. The legal position regarding a disposition made after the granting of the winding up order was that they were void because control rested with the master and the liquidator. Obviously, the position restated that once a liquidation order has been granted, the directors no longer have the ability to transact on behalf of the company. That power obviously then resting with the master and the liquidator. Paragraph 40 goes on to state the provision in section 1316 was clear on the effect a court order placing a company in business rescue had upon the pre-existing winding up order. It remained in place, not terminated, but suspended until the court, upon the application of the business rescue practitioner, determined that such suspension would be lifted, not limited. Placing the company in business rescue could not validate or undo the void disposition that occurred, and that is paragraph 41. So it follows, if the company is in liquidation and payments are made which are void by virtue of the company being under liquidation, those payments cannot be validated by virtue of a business rescue process being entered into. Right, folks, next up we go into Paja and a review under Rule 53 of the Uniform Rules in respect of removal of a director. Very, very interesting judgment of Pana versus Abso Group Limited and others. Also a reported judgment. It's 2024-1 SA Law Reports, page 491, and that is from the Gauteng Pretoria High Court. The judgment was penned quite some time back, obviously only reported now, 10 May 2023, under the pen of Snyman AJ. For those of you following along on your course notes, on the bundle, you can find the relevant page is page 41. And if you are following along in your summary, the summary can be found on page 3 of your bundle. So what transpired in the Pana matter? It was a Rule 30 application in terms of essentially the respondents in this matter cannot proceed in terms of Rule 53 because it is not a Paja review. So it was decided in the context of an interlocutory application, and what had happened here was that Mr. or Ms. Pana approached the court in terms of Rule 53 to review the board's decision to remove them under Section 71(5) of the 2008 Companies Act. The court was called upon to decide whether the review of a decision by a board to get rid of a director fell under the auspices of Rule 53. Abso contended that Rule 53 was inapplicable as the decision did not constitute administrative action, nor was it a judicial or quasi-judicial function. Conversely, the applicant sought to review and set aside his removal as a director under Section 71(5) and wanted Absa under Rule 53 to produce the record of the decision. The court examined whether the decision amounted to administrative action under Paja and whether Rule 53 was in fact applicable in this particular concept, or in terms of this particular context, not concept. My apologies, folks. So, in terms of legal principles which were discussed in this matter, the court clarified that the decision by a company's board to remove a director does not constitute administrative action as envisaged in POJA or in the Constitution. And that is that is paragraph 18 to 31 of the judgment. Fortunately for the applicant in terms of the review, the story doesn't end there. The court went on to find that Rule 53 does in fact apply to review proceedings under Section 71(5) of the Companies Act, even when the board's decision does not perform a judicial, quasi-judicial, or administrative function. The court established that Rule 53's procedural benefits should be available to such reviews, ensuring that the director or appointing parties has access to the decision record. And those are looked at in paragraphs 36, 44, and 72. So the irregular step application was dismissed. The court found that Rule 53 was in fact applicable for the review of a board's decision to remove a director under Section 71(5), very importantly, of the Companies Act. I'm going to read to you from paragraph 69, which is not on your slide, and then I'll read to you from paragraph 97 of the judgment. Paragraph 69 says that despite the fact that the reasons and or records may be available to a director, as they should have been provided with the relevant reasons as required in terms of Rule 53, there are other persons who may also make use of the same section to review the determination to remove, who had no access to the reasons for the record. And the court, for this reason, finding that under Section 71(5), that the Rule 53 proceedings do apply to the removal of a director under the Companies Act. And the high watermark, I find that Rule 53 is available to an applicant for review under Section 71(3), as read with Section 71(5) of the Companies Act, and that is on paragraph 97. Just to recap, folks, this is Pana versus Abso Group Limited and others, 2004, Volume 1 Essay, Law Reports, page 491, and that is the Gauteng Pretoria High Court under the pen of Snyman A.J. Then we are staying in terms of companies, and we are talking about oppressive conduct and protection of minority shareholders under Section 163 of the 2008 or the New Companies Act. And this comes all the way from the Eastern Cape, the Kibera High Court, and that is, its citation is 2024, Volume 1 SA 531, and that is from the Eastern Cape High Court. Judgment penned by Bands J, judgment date 12 October 2023, although it was only reported in last month's Law Reports. For those of you following along on the bundle, this one can be found on page 70 of the bundle, and the summary can be found on page 4 of your summary. For those of you who would still like to pick up the course pack, please head to thinklegal.coza and you can follow the link to our Shopify page to pick up the bundle, the summaries, and our slides for 200 smackaroonies. So, what happened in Van der Walt versus Schuman and others? And let's run through it. This is a dispute between doctors who were sole directors and shareholders of a medical practice. The case arose due to Dr. Schuman's exclusion of Dr. Van der Walt from company affairs after the latter sold her shares in the medical practice, but remained a shareholder in the company, leading to a breakdown of their relationship. Van der Walt then approached the court in terms of Section 163 of the Companies Act 71, 2008 on the grounds of oppressive conduct, and sought that Schuman buy out her shares at fair value. The court discusses the applicability of Section 163 of the Act to situations of management or voting deadlock, and especially the fact that it extends protection not only to minority shareholders, but also to any shareholder facing oppression or unfair prejudice. And that can be found from paragraph 3 to 13 of the judgment. Then in paragraph 38, the court looks at the wide discretion under Section 163 to grant relief, including directing a fair share price valuation by an objective third party. What was the outcome before we go into our notable quotes in this matter? The court directed that the first respondent purchase the applicant's shares and loan account in the company at fair market value to be determined by an agreed upon practicing chartered accountant. Essentially, the court gave the applicant an out to make sure that they are not simply ousted without getting fair market value for the value of their shares. Paragraph 3, very important. While the oppression remedy in Section 252 of the Old Companies Act was focused on the protection of minority shareholders, the remedy provided in Section 163 of the new Act protected not just minorities, but any shareholder, including one with 50% of the vote. And in this matter, obviously, we see how that could be necessary. And then a very, very long quote in paragraph 9. Accordingly, while the oppression remedy typically operates as a mechanism for the protection of minority shareholders, there exists no reason why, in an appropriate case such as the present one, my addition there from my own personal peanut gallery, given the particular facts of the matter, it is not available to a shareholder who can cast precisely half the votes in a general meeting of the company, such that the voting power is equally divided between applicant and respondent. The distinguishing feature between a deadlock situation and one involving a majority shareholders is that a majority or a controlling shareholder will not generally be granted relief under Section 163 of the Act on the basis that he or she has the power to exercise voting power to eliminate the oppression and or the prejudice of which he or she complains. The difference between the aforesaid situation and the present is manifest. In essence, what the court says, if you hold majority shareholding, you can simply put whatever conduct you are unhappy with to a vote, and you would have majority shareholding to pass the vote. In the case of a deadlock or minority shareholding, it is obviously a different story. This all the way from the Eastern Cape, the Kibera High Court, and forgive my pronunciation, and that is Van der Walt versus Schuman and others, 2024 1 SA 531 under the pen of Bands J. Judgment written in October and reported in the last law reports. Next up, we have another very, very interesting case regarding the winding up of a solvent company. This one not yet reported. Dreer versus Afristat Investment Holdings. That is 030942/22 2024 ZAGPPHC 142 is your SAFLI citation. For those following along on the bundle, page 108. Those following along on the summary, page 7 thereof. The judge, in this instance, Marais AJ, sitting in the Johannesburg High Court, and this judgment, Pretoria High Court, my apologies, Pretoria colleagues, and this judgment on the 20th of February 2024. And in fact, I was reading on the wrong line. It was in fact not Marais AJ, it was Ali AJ, ALLY AJ, sitting in the Pretoria High Court. Now, this matter deals with the winding up of a solvent company, and how fact-driven and fact-based the application is in terms of the winding up of a solvent company. See, we have a question regarding the course pack. You are more than welcome to purchase the course pack. I've just posted the link again for you. Simply go to our Shopify store and you will be able to download the entire course pack from there. So this was an opposed application for the winding up of Afristat Investment Holdings by a minority shareholder, Dreer. The application was premised on allegations that the directors had acted in a manner that was fraudulent or otherwise illegal, or that the company's assets were being misapplied or wasted. The court went on in this matter to analyze the application under Section 81 of the Companies Act, focusing on whether it would be just and equitable to wind up the solvent company based on the grounds provided by the applicant. Legal principles that were looked at in this matter looked at the interpretation and application, obviously, of Section 81, which obviously outlines the grounds on which a court may order the winding up of the solvent company. And then on a procedural basis, it looked at the necessity for an applicant to clearly plead the specific grounds relied upon for winding up under Section 81, the requirement for the company to be solvent for an application of in terms of Section 81, and the onus that rests on the applicant to prove alleged misapplication or wastage of assets and or fraud, etc. Paragraph 31, and the court does quite a lot to go into its displeasure with the applicant not being clear in terms of what their cause of action is, says at paragraph 31, a respondent must know what case it has to meet in any given case, and at a hearing to want to change the basis on which one seeks a winding is impermissible in my view. I have already dealt with just an equitable requirement above. This requirement needs to be placed in context and cannot be extracted and used as an overall additional requirement. The application for the winding up of the solvent company was dismissed with costs. The court looked quite thoroughly at the conduct of the directors and obviously found that no grounds had been made out for the company to be wound up as a solvent company. Very interestingly, in argument, the court points out that there were certain arguments where it seemed as if the company was incapable of servicing its debts, and the court basically said that this is not applicable to Section 81. For Section 81 to apply, the company must be a solvent company. That is the jurisdictional requirement in terms of Section 81 for winding up. Right, on that note, and I'll repeat the citation for those of you obviously not yet reported in the law reports, Dreer versus Afristat Investment Holdings, 2024 ZAGP PHC 142, under the pen of Ali A.J., and that is the Pretoria High Court. The last month on the 20th, this judgment landed. Page 94 in your bundle, and summary can be found on page 6 of your bundle. Right, that, dear friends and colleagues, takes us through our 5 companies and corporate governance judgments, going all the way from business rescue to winding up to protection of minority shareholders. Some interesting judgments. Of the 5 that we went through, 4 had in fact made it to the law reports during the course of last year and were reported in our last edition of the SA Law Reports. Next up, we are going into some litigation matters, and we have 2 litigation matters to share with you this week or this month. As I'm sure you can all appreciate, we have a lot of judgments that are landing, especially for those of you who are on the Spartan Case Law Service. You'll know there are at least 10 judgments being sent out every day. So to go through 13 judgments, we are scratching the tip of the iceberg. However, I really do hope that the judgments which caught my eye, which I think are interesting and that you should know about if you are in the practice of commercial law litigation or labor law, are of interest and are helpful to you. Right, the first one under our litigation section is Mervyn Trading CC versus Abso Bank Limited. This is a reported judgment from the SA Law Reports 2024, Volume 1, SA, page 478, and that is in the Gauteng, Johannesburg High Court. Now, this is the one that is under the pen of Maria AJ, and it was penned on 23 May 2023, although it was only reported last month. Those following along in the bundle, you can go to page 108. If you're following along on the summary, please go to page 7, and you will find Mervyn Trading CC versus Abso Bank Limited. Now, what had happened in this is it's quite a simple statement or a principle which was restated, and a point that was taken by Mervyn Trading CC against Abso Bank in the Johannesburg High Court, and the matter dealt with the issue of jurisdiction, and the CC, which was the applicant in this instance, tried to distinguish between the requirements in respect of companies and in respect of CCs, in respect of principal place of business versus a registered address, and what we look at here colloquially referred to as the dual jurisdiction principle. So the applicant, Mervyn Trading, brought an application for rescission of a default order, which was granted against them for the delivery of a motor vehicle in favor of Abso Bank, where the vehicle was obviously financed. So central to the dispute in this case was whether the Gauteng division of the High Court had jurisdiction to entertain the matter or to adjudicate the matter based on the fact that Mervyn Trading's registered office was within the jurisdiction of the Johannesburg High Court, despite its principal place of business and the cause of action being located in Polokwane. So in this instance, the court explored the principle of dual jurisdiction applicable to companies and its relevance to, for those of you with an eagle eye, this is a CC, and it's interesting to see that there are still closed corporations that are still kicking and screaming and still doing their thing, where I do believe most organizations have converted to proprietary limited private companies. So what were the legal principles discussed and where are they discussed in this matter? Closed corporations are deemed resident at both their registered office and principal place of business, invoking dual jurisdiction, paragraph 55 to 56. Superior Courts Act, section 21, provides that a division of the High Court has jurisdiction over all persons and matters within its area, including the registered offices of corporations. That's paragraph 23 or 29 to 31, apologies. And then the court also looked at section 34 of the Constitution, ensuring access to courts, which necessitates the recognition of dual jurisdiction for closed corporations, and to prevent a denial of court access due to uncertain principal business locations, as those who frequently litigate against companies will know that the registered address works very similar to a domicilium address. Paragraph 59 and 62, the court talks about the section 34, access to justice in terms of the Constitution. Legal position regarding closed corporations is unaffected by the promulgation of the 2008 Companies Act. Dual jurisdiction principle that applied to the companies prior to the 2008 Companies Act also applied to closed corporations, paragraph 56. And then paragraph 65 to 66. The court had some very strong words to the applicant, Mervyn Trading. The applicant clearly has no defense to the respondent's claim for delivery of the motor vehicle. Upon learning of its granting of the order for delivery in this matter, the applicant failed to deliver the vehicle to the respondent as he was contractually obliged to do. Instead, they brought the present application for rescission of the order. This application is clearly a reprehensible delaying tactic, justifying a special costs order. The court saying essentially, pull the other one. We are going with a dual. We're going on dual jurisdiction, as I think common sense dictates that we do. That was Mervyn Trading CC versus Abso Bank Limited, 2004, 1 SA 478 GJ, under the pen of Maria AJ on 23 May 2023, reported last month. Really just edifying the dual jurisdiction principle in respect of companies and closed corporations. Then we have an interesting matter of Trident South Africa Pty Limited and another versus Taylor and others. This is as yet an unreported judgment. It landed all the way from Pretoria on the 6th of February 2024 under the hand of DeForce AJ. For those of you who are following in the bundle, page 131, you can find this judgment, and on page 8 of the summaries which I have prepared for you. Now, in this instant, there was a dispute between the applicant in this matter and the respondent, where there was a alleged removal of confidential information by the respondent from the applicant's servers. The parties then entered into a settlement agreement, duly signed by both parties, and the applicant then wanted to confirm a rule nisi based on the settlement agreement which was signed. The respondent then approached the court saying that the agreement or the settlement agreement was entered under duress and should not be made an order of court, and then obviously sought that the rule nisi not be confirmed. So the court went into a fairly deep discussion of settlement agreements and their enforceability as court orders. That's at paragraph 56. The court looked at the principles governing the extension of a rule nisi in paragraph 27, and the court quoted from two very interesting matters. The first one, which is on your screen there, MedScheme Holdings Pty Limited and another versus BUMG. It is not unlawful in general to cause economic harm or even to cause economic ruin to another, nor can it generally be unconscionable to do so in a competitive economy. And then further, it goes on to say the exercise of free will is always fettered to some degree by the expectation of gain or the fear of loss. And then paragraph 56, quoting from Road Accident Fund versus Taylor, a court has no power or jurisdiction to embark upon an inquiry as to whether the compromise was justified on the merits of the matter or was validly concluded. And the court in this instance rejected the respondent's opposition and allegations of duress and confirmed the rule nisi and made the settlement agreement an order of court. So if you sign a settlement agreement because you're scared of the repercussions, if you don't, be very careful of Trident South Africa Pty Limited and another versus Taylor and others. Citation once again, ZAGP Pretoria High Court 122. That is our Safley citation under the hand of DeForce AJ on the 6th of February 2024. Now, very interesting next matter. We're going into the realms of labor law. Before we go there, reminder to those who just joined us, visit thinklegal.co.za, our website, finally online, and a lot of the resources that you can find there. You can also go to vermeulenlaw.co.za, register for events, join our WhatsApp groups, purchase resources, and view past webinars using those website details. For those of you who have not yet purchased the course pack for today, it includes the 13 judgments that we are working through. It's about 260 pages of judgments, 17 pages of summaries, as well as our slides, which are designed to fast track you into understanding and reading these judgments for yourself. For those of you who would like to pick them up, it's a great way to support us in keeping these webinars free. Please go to our Shopify page and you can purchase our course pack for 200 Rand. If you are not inclined to do so, you are still more than welcome to attend the webinar today, which is absolutely free of charge. On that note, we go into the realms of labor law, and we have three very interesting judgments for you today, one reported and two unreported. The first emanating from the Johannesburg High Court, which is, I think, an incredibly important judgment to take note of. Just for the person asking about the Children's Act deep dive, I'll be going through the fees at the end of the webinar. Again, there is a slide for it, so please stand by. And we will deal with that now. So, Van Wyk and others versus Minister of Employment and Labour. This was a reported judgment penned on the 25th of October 2023 under the hand of Sutherland DJP in the Johannesburg division of the Gauteng High Court. For those of you following in the bundle, page 242, summary on page 9 of your summary bundle, and then the full citation 2024 volume 1 SA 545 GJ. And this is an important judgment insofar as it deals with the issue of maternity and paternity leave and whether the relevant sections under the Basic Conditions of Employment Act, namely Section 25, 25 Cap A, 25 Cap B, and 25 Cap C of the BCEA are constitutional or not. So the applicant in this case challenged the constitutionality, asserting that they unfairly discriminated between different types of parents, birth, adoptive, and commissioning parents in surrogate agreements, and also between mothers and fathers in terms of leave entitlement. The court agreed with the applicant and found that these provisions are inconsistent with sections 9 and 10 of the Constitution relating to equality and dignity due to the differentiation based on gender and parental status. So what are the legal principles discussed? The provisions differentiating between types of parents and mothers and fathers were found to be inconsistent and to be inconsistent with constitutional guarantees of equality and dignity. And there was then obviously a declaration of invalidity in respect of the offending legislation, and that is paragraphs 23, 24, and 26 are the touchstone parts of the judgment that you absolutely should have a look at. So what happened in this instance? The court declared the challenged sections of the BCEA and the corresponding provisions of the UIF Act invalid due to inconsistency with constitutional imperatives of equality and freedom. Declaration of invalidity was suspended for 2 years to allow Parliament to amend the legislation, and obviously interim measures were put in place, essentially allowing parents to share 4 months of parental leave, divvied however they want to divvy it. Obviously, the next step is for this declaration of invalidity to be confirmed by the Constitutional Court. And for purposes of today, I'm uncertain whether that has taken place yet, but no reason to believe that the Constitutional Court won't follow suit with the Johannesburg High Court. If anyone has further information on this, please feel free to pop it in the chat bar for the benefit of all the attendees. Notable quotes from this judgment: upon the premise that the leave entitlements and duration of the leave are provided for the purpose of the nurture of a baby or toddler, not merely to allow literal physiological recovery from giving birth, it seems plain that the distinctions made in the BCEA are at odds with the objectives of sections 9 and 10 of the Constitution, and also at odds with the norms inherent in the Children's Act. And quite pleased that Sutherland DJP brought in the provisions of the Children's Act as well. The first irrationality, that is at paragraph 23, incidentally, of the judgment. Paragraph 24 says the first irrationality is the provision of a 10-week period of leave for commissioning and adoptive mothers rather than a 16-week period of leave as provided for a birth mother. And then at paragraph 26, to accord a paltry 10 days leave to a father speaks to a mindset that regarded the father's involvement in early parenting as marginal. I think a very, very big win for constitutional imperatives of equality and dignity. I would love to hear from all of you regarding what you think of this judgment. Please don't be shy. Pop your thoughts in the comments, whether you are watching us from YouTube land, StreamYard, or even on our LinkedIn page. Please let us know what your thoughts are. Now, the next judgment is a very, very interesting judgment, which I managed to get my hands on this last month. It has already been, it's almost past its first milestone in terms of a 6-month period since it was handed down, 12 September 2023. And this was Labour Court of South Africa in Johannesburg under the pen of Moshuana J. You can find it on page 145 of your bundle, and the summary is on page 11. When I came across this judgment, even though it's a few months old, I thought, let me pop it in for you, just because it was, in my thinking, a very, very interesting judgment relating to racism and a dismissal for racism when the racism took place not on the company premises, but on the personal social media page of the employee. And the judgment here is Van Straten versus Commissioner Julius Winke and others. It's a review from the Joburg Labour Court, case number 1876 of 21, under the pen of Moshuana J. Bundle page 145, summary page on page 11. Now, what had happened here was the employee brought an application to review and set aside an arbitration award finding his dismissal by the organization undoing tax abuse procedurally and substantively fair. So the CCMA essentially rubber stamped the dismissal as procedurally and substantively fair. The dismissal was as a result of the employee making racist remarks on an open group on Facebook against one Mr. Singh, and Mr. Singh approached the apologies there, folks. My just having a bit of a senior moment there for a second. The said Mr. Singh approached the various role players in terms of his human rights being infringed as a result of the racist remarks on Facebook. Despite the defense of exercising freedom of expression, the court held that the remarks constituted racism and the dismissal was fair. And incidentally, the organization I was thinking of, or the body I was thinking of, it was the Human Rights Commission. And apologies for my brain slip up there. So what were the legal principles discussed? Paragraphs 25, 28, and 31. And be warned, this is a very long judgment. The court goes into quite a lot of detail regarding inflammatory and irrelevant matter placed before it. It looks at racism in the workplace, obviously justifying dismissal, and correctly so. Paragraphs 25, 28, and 31. The boundaries of freedom of expression do not protect discriminatory or racist remarks. That's paragraph 51. And then obviously the test for reviewing arbitration awards, which involves considering whether the arbitrator's decision falls within the range of reasonable outcomes based on the evidence. That's page or paragraphs 52 and 54. The review application was dismissed. Costs were ordered against the employee on an attorney-client scale. Paragraph 61, not on your slides. However, paragraph 61, very important. The court just affirms freedom of speech is not an absolute right. Referring to the conduct of the employee in court, the applicant remained adamant, remorseless, and defiant. His unsubstantiated attacks on the reputation of the first respondent ran like a golden thread throughout his lengthy and mostly unsubstantiated, belligerent comments. His lack of appreciation or willingness to accept accountability and responsibility for what he had done is beyond apprehension. It should also be noted that he downplayed the severity and seriousness of his misconduct by being overly critical of the process followed when, as I will deal with underneath, there was nothing sinister taking place in the way that the first respondent handled the arbitration. When applying the above to the matter at hand, the fact that the applicant made his comment in his personal capacity and on his personal page did not safeguard him from facing the consequences at work. And I think the court correctly finding that a dismissal based on racism outside of the office on social media is absolutely justified. That was, just to wrap up that section, that was Van Straten versus Commissioner Julius Wenck and others, JR 1876 of 21, bundle page 145, summary page 11, under the hand of Moshwana J, 12 September 2023, and Johannesburg Labour Court. Right, moving swiftly along, and we are about 2/3 through our session for this morning. Next up, we go into Department of Health, Gauteng Province, and another versus Elroy, Tinteni, and others, JO1 of 2024. This deals with the urgent court in the Johannesburg Labour Court judgment dated 27 February 2024 under the hand of Prinsloo J, bundle page 159 and summary page 12. What had happened in this instance was an interesting comedy of foibles, if one can put it that way, in terms of delays in bringing an urgent application. So what had happened here was the Department of Health, Gauteng Province, and the MEC for Health, who were the applicants, sought judicial review of a disciplinary decision regarding misconduct of certain employees. The employees were cited as respondents in the matter. The chairperson in the disciplinary hearing issued a sanction of final written warnings and 2-month suspension without pay for theft of PPE equipment, which the applicants, being the department, contended was irrational, unjustifiable, and unreasonable. They sought to have the decision reviewed and set aside, with dismissal as the substituted sanction. Where the applicants in this instant had some difficulties was with regards to the aspect of urgency. What had happened here is there was a delay of nearly 2 years from the disciplinary, and I had to read over the paragraphs a few times myself. I thought this does not sound right. The disciplinary all the way back in 2022, and there was long stories about people who were dismissed or people who had resigned, and then there was chaos and all sorts of things. And essentially, the matter was struck off the roll for lack of urgency, just because of this inordinate delay and self-created urgency. Paragraphs 8 to 10 in the judgment looks at Rule 8 of the Labour Court rules and edifies that in legal applications, urgency requires the applicant to explicitly set out the circumstances that render the matter urgent and justify why substantial relief cannot be attained in a hearing in due course. And then the court reiterated paragraphs 11 to 14 and paragraph 37 that self-created urgency resulting from an applicant's inaction or delay is not entertained for preferential treatment in urgent court proceedings. Thus, matters struck off the roll for lack of urgency. Paragraph 12, it's tried that an applicant is not entitled to rely on urgency that is self-created when seeking a deviation from the rules. Paragraph 34, the applicable authorities confirmed that an applicant cannot sit back and do nothing and later seek the court's assistance as a matter of urgency. And very interestingly, paragraph 48, which is not on your slides, but notable nonetheless, the urgent court is being abused. Might I state, an urgent court is meant for urgent matters. This court should not be detained for use of its scarce valuable time entertaining self-created urgent matters. Thus, the matter struck off the roll for lack of urgency. Next up, folks, we are going into the realms of contract law. I've got one judgment for you today based on an on-demand guarantee. Just before we go back into that, just to recap, citation, Department of Health, Gauteng Province and another versus Tinteni and others, J01 2024, Joburg Labour Court under the pen of Prinsloo J, bundle page 159, summary page 12, and that landed on 27th of February 2024. Next up, I would like to refer you to Innova Turnkey Pty Limited and others versus Hollard Insurance Company Limited and another, and this also and as yet unreported judgment, ZAGP Johannesburg High Court 115, judgment landed on the 9th of February 2024 from the Johannesburg High Court under the pen of Docio J, and that can be found on page 175 of your bundle, page 14 of your summaries. Now, what had happened in this instance is there was a dispute between the contractor and the client, and in this context, there was a on-demand guarantee which was issued. So there was an urgent application by the applicant Innova Turnkey and others seeking to interdict Hollard from making payments under two on-demand guarantees to Blue Wave Properties pending arbitration proceedings. The guarantees in question were an advanced payment guarantee and a construction guarantee. The client, Blue Waves, called upon these guarantees following alleged breaches by Innova. Hollard did not oppose the application, while Blue Waves did. Now, the court's decision hinged on whether the grounds for an interdict were set out. And very interestingly, the court went into the principle that an on-demand guarantee is independent from the underlying contract, and a guarantor is obliged to pay, provided that the demand complies with the terms of the guarantee. The only exception, and incidentally, that was paragraph 34 to 39. Court goes on at paragraph 46 to 49, setting out that the only exception to the autonomy principle is if there was clear fraud by the beneficiary of the guarantee. Paragraphs 33 to 34 doesn't bear overstating. The court looked at the criteria for granting an interim interdict, obviously being a prima facie right, apprehension of irreparable harm, balance of convenience, and the absence of any other satisfactory remedy. The urgent application for the interdict was dismissed. The court found that court should not focus on the underlying contract when ruling on interdict cases about payment of under an on-demand guarantee. That's paragraph 41. An on-demand guarantee is payable on demand. Hollard is not entitled to interrogate whether Innova or Blue Waves actually breached the underlying contract or not. The demand complied with the terms of the guarantee, and therefore the party had to, the guaranteeing party had to pay out the guarantor. Then reminder, thinklegal.coza, register for events, join our groups, purchase resources, or view past webinars. Then finally, folks, I have two more judgments for you. The first going into the realms of unjustified enrichment, all the way from the Pietermaritzburg High Court in KZN. And this is another unreported judgment which came to light on the 8th of February 2024 under the hand of Sabisi AJ, bundle page 191, the summary page, page 15, full citation. Heer and Another versus Govender, 2024 ZAKZPHC 7 Safley reference. Now, this is quite an interesting matter in terms of an unjustified enrichment and extortion claim against an alleged psychic by a person who made use of their services, or one person, in fact, with assistance from a family member. The plaintiff sought recovery of substantial sums of money from defendant on the grounds of unjustified enrichment. The matter stemmed from payments made to defendant who misrepresented herself as a psychic capable of communicating with the deceased mother of the first plaintiff. The payments escalated under duress and threats, leading to claims against the alleged psychic based on unjust enrichment and fraudulent misrepresentation. What had happened in this matter is the first plaintiff obviously had lost her late mother, struggled to deal with it, and then through an advertisement managed to get in touch with the defendant. The defendant made several demands in respect of monies and very lavish gifts payable by the first plaintiff to her. In total, the funds expended by the first plaintiff to the defendant was approximately 4.99 million rand, including gifts, including heirlooms which were handed over, and all and sundry. In this matter, there were expert witnesses which testified. On day one, the defendant was in court. Day two, they simply did not pitch up, and the court proceeded on default. So what are the legal principles that we look at here? Unjust enrichment occurs when one party benefits at another's expense without a legal justification, and fraudulent misrepresentation involves a false statement that induces another to act leading to damage. And then the court also looked at extortion, which refers to obtaining benefits through coercion or threats. What happened in this case? The defendant was ordered to pay the first plaintiff an amount of 4,992,000 rands and a few additional 100 rands. Then second, in respect of second plaintiff, who was the father of the first plaintiff, 540,000 rand. So essentially a money judgment of just under 5.5 million rand payable by the defendant to the first two plaintiffs. The matter was also referred to the National Director of Public Prosecutions for consideration of possible criminal proceedings against the defendant. The court obviously not swayed in respect of the alleged psychic abilities. Extortion aimed at obtaining an advantage in the form of payment offends the rights of the first plaintiff. That's paragraph 49. Second contract was accordingly entered into for an illegal purpose, and it is thus illegal first plaintiff is entitled to restitution, paragraph 50, and then also just that the balance of probabilities favor the evidence of the plaintiffs and experts. That is Heer and Another versus Governor, 2024 ZAKZ PHC 7, KwaZulu-Natal High Court, and that was under the hand of Sibisi AJ on 8 February 2024. And then finally, we go into a single matter on deceased estates, and here we're going to look at the validity of a will. Mohanwe and others versus Master of the High Court, Johannesburg and others. Full Safley citation 2024 ZAGPJHC 155. For those of you following along in the bundle, page 226, and the summary bundle, page 17. This was heard by Norco J. Judgment penned on 19 February 2024, all the way from a very sunny and warm Johannesburg today. So, what had happened here was there was a dispute over the validity of two alleged wills of the deceased, which were presented to the Master of the High Court following his passing. Both wills lacked witness signatures, leading to initial rejection by the Master. One was typed, the other one was handwritten. The main contention lies in the differences between the wills regarding the bequest of the deceased's immovable property. The court was called upon to determine the rightful will and address additional issues such as the conduct of the first applicant, who was the executrix, and the manner in which the deceased estate was managed. What legal principles did the court look at in this matter? The court looked at the requirements for the validity of a will under Section 2 of the Wills Act 1953, specifically the necessity for a will to be signed in the presence of two witnesses, and obviously quite correctly the Master of the High Court rejected the wills based on non-compliance with the Wills Act. So that's looked at paragraph 38 of the judgment. Paragraph 48 to 54 of the judgment, the court looks at the role and responsibilities of an executor or an executrix in managing an estate, highlighting impartiality and fiduciary duties and the circumstances under which they may be removed in terms of Section 54, 1 Roman 5 of the Administration of Estates Act. That's at paragraphs 48 to 54. The court dismissed the main application and it dismissed the counter application with one exception, and that is that the first applicant was removed as the executrix of the estate. The court directed the matter to the Master to appoint another executor or executrix, and very interestingly, in terms of the costs order, it found that each party shall pay their own costs, but that none other parties are able to mulct the deceased estate for the costs incurred. And there were two notable quotes from this judgment. The first, the rationale to have witnesses of the execution of the will is inter alia, that since the essence and interpretation of the will is considered after the demise of the testator, such witnesses would come forward and assist the court or the parties in resolving any impasse whenever it lurks, including even to confirm that indeed the testator is the person who executed the will. That's in paragraph 39. And then finally, in paragraph 54, it is certainly undesirable to be a creditor and the executrix, and further putting the law in motion to advance a case which tends to prefer one beneficiary against the other. And that is paragraph 54 of the judgment. Then to wrap up, Safley citations, ZAGPHC 155, Mohanwe and others versus Master of the High Court, Joburg, and others under the pen of Norco J on 19 February 2024. Finally, we look at TR versus SR, and my apologies, folks, that I actually had one more for you. This comes all the way from our family law roundup last week, and that is the setting aside of a writ of execution if the judgment was not definite. I've kept it for this one as well. And let me just open my notes from the family law roundup last week, where we initially looked at this matter. And essentially what had happened here, it was an application to set aside a writ of execution where the amount payable under the judgment was not ascertained, and there was quite a few problems. The court found that the writ was materially defective and that the respondent who was opposing the setting aside of a writ couldn't go to quantifying the judgment in answering affidavit, and that you should have done so in her founding affidavit when the writ was applied for. If you would please bear with me, I will share with you the full citation of that judgment shortly. That can be found. I do believe it was a Johannesburg matter. If you will please just bear with me. Let's have a look. That is, let me close file 1 and open file 2, if my computer is going to comply with my request. And that is TR versus SR. And your citation on that is 2024 ZAGPJHC 76. And that is under the pen of Van Nieuwenhuizen AJ. So, folks, that brings us to the end of the commercial law roundup for February. As promised to the person that asked regarding the Children's Act deep dive, 23 and 24 April 2024, 5:30 to 8 o'clock. Day 1, we look at general principles all the way from best interest of the child standard to co-parenting, etc. Part 2 and 3 taking place on day 2. We look at children's litigation overview and frequently encountered issues. Standard tickets, 750 Rand per person, which includes your course packs. 500 Rand per person for candidate attorneys. Use the promo code TL Earlybird for 20% off until the 20th of March 2024. Go to Quicket to register, and this is a SARM NABFAM appointed, SARM being a constituent body of NABFAM accredited course for 5 CPD points. And that, dear friends and colleagues, concludes the commercial law roundup for February 2024. I have been Mervyn Vermeulen, and it has been absolutely lovely spending this hour and some change. We come in 10 minutes before the closing time of this webinar, so I can release all of you back into the wild. For those of you who are interested, please go to thinklegal.co.za to register for some of our upcoming events, including the Children's Act deep dive, as well as the next family law and commercial law roundups taking place early next month. And also for those of you who are interested to support what we are doing here in our quest, as it were, to spread sound legal knowledge, you are welcome to support us by purchasing our course pack for today, which includes the 13 judgments that we looked at, as well as their summaries and our slides. It certainly assists us in keeping these webinars free to attend. So, folks, thank you for spending your Friday morning with me, Mervyn Vermeulen, as well as Nadia and Cathleen, who were helping in the back end with this presentation. And I look forward to seeing you for the next one. For those of you who are on the WhatsApp groups, I will see you in WhatsApp land. For those of you who are not, what are you waiting for? Go to thinklegal.co.za and apply to attend or to become a part of those WhatsApp groups. I hope that I've given you some interesting weapons in your arsenal when it comes to commercial litigation and labor law matters. And I wish all of you a wonderful weekend, and we will see you again at the next one. I'll be ending the stream now. Have a great Friday, everyone, and goodbye.